Lastly,
Which one?
I think so. Is that the one that we use?
I know, but sometimes it's not supposed to.
I know, I don't remember.
Jocelyn's in the back.
In the office.
Oh, okay. Oh, you guys, they moved the back.
Yeah, they moved.
Okay, yeah, because I stuck my head that way. I'm like, oh, it's empty.
Now we're building the building. So it's building.
Oh, okay. Oh, nice. So I have to visit the
Yeah.
construction looks like it's going good.
Yeah, construction.
Yep. Good morning, everyone. We'll be getting started very shortly.
Good morning, everybody.
Good morning.
We need something else.
Ready?
Go.
Good morning, everyone. Thank you so much for your patience. The time is now 9:17, and we will be commencing our special magistrate hearing. Today is February 21st, 2024. Before we begin, I will be reading an opening statement, so I do thank you for your indulgence. Ladies and gentlemen, welcome, and thank you for being here today. Please turn off any cellular telephones to avoid interrupting these proceedings. There are no weapons of any kind permitted in the chambers or anywhere else within these facilities. In all issues that may come before the special master, we ask that everyone show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. These are hearings conducted by a special master, that is me. My name is Andre McKinney, the purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer, which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I am the special master assigned to hear today's cases. My responsibility is to act much like a judge in a court, and that is to hear cases presented by the code enforcement officer and to hear contradictory arguments presented by any alleged violator. These hearings are open to the public. It is required that all persons who testify as to the facts of the case be placed under oath, including the code enforcement officer. These hearings will not be conducted in accordance with the formal rules relating to evidence and witness. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witness, regardless of which party first called him or her to testify, and to rebut the evidence against him or her. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special master are limited to whether the alleged violation occurred and, if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. I have the authority to assess and order the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of the civil penalty, the administrative cost of the hearing of not less than $100, if so assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the city, may appeal a final order of the special master to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the special master. An appeal shall be filed within 30 calendar days of the issuance of the order sought to be overturned. If you are found guilty of the civil violation charged, you will be assessed an administrative fee of $100. The city representative will present their case first, and the alleged violator will present their case thereafter. I will consider the evidence and render a decision after all arguments are heard. Thank you. And Officer Ramirez, we may commence today's hearing.
Okay, we will begin with the roll call. Chief Code Officer Ramirez, present.
Assistant Interim City Attorney Brian Sherman.
Special Master Andre McKinney.
Code Compliance Clerk Nasli Cardona.
Building Clerk Mary Carey Paz.
Okay, and next item is the adoption of the agenda. We have two modifications. I've added case 6999 to abate the fine, case 7958 to abate the fine. And if it's approved, then we can continue with any cases that have a present attorney.
So approved as presented.
Okay. Is any attorney present today? Okay, we'll begin in the order of the agenda. The first case is 6622. Chief Code Officer Joseline Ramirez for the town of Pembroke Park, case 6622. Property owner Miguel Romero. Site address 131 Janice Boulevard, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail, January 16, 24, posted to the property and town hall, February 9, 2024. It is the town's motion to extend the time for 90 days. The per diem and the admin fee of $100. The per diem stays the same and the $100 admin fee is imposed.
Officer Ramirez, does that conclude your presentation?
Yes.
Is there anyone here on case number 6622? Please come forward. Can you please state your name and your relation to the subject property?
Leison Maldonado. Yo vengo para pedir la extensión del señor Miguel Romero para terminar el proceso de la documentación y los permisos.
Okay, can you say that in English? And I'm gonna turn on the mic, or can you press the button on the mic? So it turns on green? Where it says push, yeah. Turn it.
My name is Leison Maldonado. I represent for Miguel Romero. I got a 90-day extension for process complete the plans and permit for legally everything violation.
And you said you represent the owner of the property. Who are you in relation to the owner?
This runner for the papers and he working for the architect.
Are you the contractor?
No.
Who are you?
I got a work construction, but I'm remodeling.
You're doing the work.
Yes.
Okay, and you're here on behalf of the owner.
Yes.
Okay. Anything else you'd like to add?
That's it.
Okay, and the per diem is 100?
Yes.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for an extension. The respondent is hereby come into compliance in 90 days. The failure to correct the violation and come into compliance will result in fines continuing to accrue daily until the property is in compliance. That is $100 per day daily fine. The respondent is assessed $100 for the administrative cost of today's hearing. Okay, if you could step to the
Kenny,
side.
if I may?
Yes.
We skipped the swearing in, so at least let me swear
Oh,
in.
yes, we sure did.
Sure. I just want to swear in this gentleman, and then we'll swear in everyone else.
Yes. Can you raise your right hand?
Everyone, please raise your right hand, and gentlemen, you're going to swear that the testimony you just gave is the truth, the whole truth, nothing but the truth, and everyone else is the testimony you're about to give, the truth, the whole truth, and nothing but the truth. Do you swear or affirm? Thank you.
I do.
Thank you. That's one of the most important components. Thank you so much, Attorney Brian. Whenever we're ready for the next case.
Next case is 5123. Chief Code Officer Joseline Ramirez for the Town of Pembroke Park, case 5123. Property owner Scott Heathen and Alex Mueller. Site address 3487 Southwest 52nd Avenue, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail January 31st, 2024, posted to the Property and Town Hall February 9, 2024. It is the town's motion to confirm the fine of $2,100. This property came into compliance on December 9, 2021.
Is there anyone here on case number 5123? Good morning. Can you please state your name for the record and who you are in relation to the property?
My name is Scott Heaton. I am owner of the property in question.
So you've heard the town's position. We're here to confirm the fine. The record reflects that the property is in compliance, but there is a fine amount. So what's your position with regards to that?
My issue is I would either like to have it, I don't know any legalese, but either removed or reduced. My reasoning is in the difficulty of getting someone to sign off on a previous, I'm talking about the shed right now. So the shed being put up was before I was owner. You can't find a contractor who would sign off on a deed going up. Every contractor I tried to find to take it down either did not want to register with the town or was more interested in doing my bathrooms and kitchen. I've had a lot of these discussions with the front desk. I'd been in here many times looking for a personal, forgive me, words are slipping. To pull my own permit, unfortunately, and I believe this was mentioned before, that the association has everything. I need to get permission from the association. That was a delay. I sent an email. Their reply to me was, well, then you got to get a permit. Well, that's not helpful because I need documentation to state. So that's another holdup. Lucy helped me find, finally, a contractor who was willing to put in the paperwork, and I could find somebody to actually do the job. He'd do the inspection. He did the oversight on the whole project. Turns out, in my luck, the individuals who put up my fence, they were good enough to take down the shed, and I could finally complete the fence. So it did take a period of time. I would also like to state that we probably lost a month on top of that, being under quarantine twice. I do have some letters from the association, if those are even relevant. I don't know where you're telling me I have a certified mail. I've not received that. I remember in our meeting previously, you told me that we had certified mail. Well, I found the letter, and I think this is a certification,
Yeah, so you sign it and you have to,
but it was not signed by anyone.
okay. How did
Yeah.
you receive that envelope?
Probably just in my mailbox,
Okay.
which is why I'm stating I didn't receive yours. It's probably sitting in my mailbox.
So sometimes property owners don't sign and send it back, and that's why the code compliance officer will go to the property and post it. The hearing.
No, that's all fine. My thing was to say that it was some certified mail when I didn't certify it kind of feels a little like, where's my control in something like that if they're going to drop it in my mailbox?
That's a form of mailing. That's a form of mailing that the officer is required to
Required to
provide in
do,
the
okay.
posting. And so it's just simply sending out the mail, whether actual receipt of the mail, as long as it's addressed to the proper owner as listed in the public records, that satisfies the notice requirement under the statute. But for today's hearing, we are here to confirm the fine. The total amount based on the number of days that it's been out of compliance is $2,100. That does include the $100 administrative fee. The town does have a process in which to address mitigations, and it sounds like that you have stated there are grounds or reasons why you had delays in coming into compliance prior to the accrual of the fines. And so what I am going to recommend as I provide my oral pronouncement, unless you have anything else to add.
I'm sure I do, but I can't think of anything right now. Sorry, I'm very nervous. And it's good to see you, actually.
Likewise.
No need to be nervous.
Too late.
We appreciate your honesty. So to that extent, my oral pronouncement is that based on the testimony and the evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. The fines are hereby confirmed. The amount is $2,100. It does include the $100 administrative assessed fee for today's hearing. You must pay that amount within 30 days. With regards to the request of reducing that amount, the town does have a mitigation process. You can check in with the Code Enforcement Division. They'll provide you with those steps for doing so, and that will come back before the special master for consideration of any reduced amount. So there is a process for that, and you can set forth all of the reasons that you indicated in that form.
All right, beautiful. And I assume they'll speak to you?
Right. You can pass by the building
now.
department, and Jeffrey can probably give you a mitigation form. And the form is also available on the website if you want to do it at home.
All right, beautiful.
Okay.
Thank you.
You're welcome.
Ms. McKinney, if I may just make one small correction.
Yes.
As far as you said, that's due and owing in 30 days. It actually is due and owing now.
Oh.
But again, it's going to be a lien on the property. But as far as the 30 days is that was the misstatement. It's due and owing now. If you end up getting the reduction, then the reduction would then be due in 30 days or whatever time set by the magistrate. Because if you don't pay the reduced amount within the time frame, it automatically
resumes.
It resumes. But this one, the $2,000 is the full amount.
Did you understand that?
Not a word.
Okay, so and a little less legalese, the $2,100, technically that is due to the city right now.
Okay.
You are in compliance, that's on the record. Now, any reduced amount that you apply for and is approved, that you get 30 days to pay. So what that means in the interim between now and when you apply for a mitigation, and if it's approved, the town does have the right at this moment to record a lien on the subject property. Why? It's because that amount is due to the city. You're in compliance, but for the number of days you were out of compliance, the fines accrued. And so under the law, they do have the right to lien the subject property. So you are strongly urged to submit your application for mitigation so that that can come back before the special magistrate for consideration for a reduction, if any.
So if the reduction, I would have to come for another hearing, or that would be received in mail, or how?
I'm going to lean on the town for clarification. Can you advise whether or not if a reduction is approved, if the owner or the respondent is notified, and if they so elect to come to the hearing?
So I can send you an email stating to you what the town position is as reduction-wise. And if you agree in the amount, we can do an agree order, and it's optional if you want to attend the hearing.
Okay. Next question. If I just paid the full amount and then put my grievance, then it would be refunded, therefore I'm in compliance, and then No, she's saying no. She must know something.
I let the record reflect my face, my mouth isn't saying anything. But what I will say is that I've never seen that. I'm gonna allow the town to speak to that. But Officer Ramirez is shaking left to right.
Ms. McKinney, if I may. At that point, once you pay the fine, then at that point it's complies.
moved.
Therefore, there would be nothing to reduce.
Right.
I understand.
So it's either if you want to pay the fine, if you'd like to go through the reduction process, you're more than welcome to go through that process.
Okay. I think I'm done now.
Yes, and Nasli will provide you a copy of the order, okay?
We can call the next case when you're ready.
Next case is 6522. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 6522, property owner Christian Cavalier. Site address 142 West Lake Drive, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail January 31st, 2024. Posted to the property in Town Hall, February 9, 2024. It is the town's motion to reduce the fine of $9,900 by 90%. That is a total of $1,080.
Is anyone here on? Perfect. Can you come forward?
Hello.
Good morning. Can you please state your name and your relation to the subject property?
My name is Christian Chevalier, and the address is 142 Westlake Drive.
Okay, so the town has agreed or is offering a mitigation reduction of 90%, reducing the amount from $9,900 to $1,080.
Yeah, we did receive that. We did receive that, but only yesterday at 4:15 p.m., which when we brought all the papers in, Mr. Gustin told us the only thing he said, this is the paper we're giving you to go to mitigation. And that's all we did. We entered everything, and why we're contesting is because we never received the first letter in 2021. And I've got the proof here, and which is in your file, that it was returned to sender. If you want a copy, I've got full copy of everything I'm talking about.
You want that?
Yes, can you bring it for,
The return to sender is number 3. We would never be here if we would have received everything at the beginning, because if you go see at number 5, the letter that we found, that's in the water. That's because we're finally found out that we had case, and it was on the floor.
Do you reside here all year long?
No, we snowbirds, we get here from November till April.
Okay, did you check with the post office to see why it was returned? Sometimes
I didn't know. I just found out in November when we got
Okay,
here.
sometimes people lock their mailbox and that's why it's returned
But
sometimes?
we take it off because if the wind, with all the hurricane that's here.
So when
Ryan?
mail is not received, you always have to check with your local post office.
But the mail was sent on the date of November 16. And if you take a look at number 2, there is a photo seeing that we're there on the 12th. November 12th. We're actually at the house. You see my post, my mailbox, you see my car. So why the post didn't give it to us?
Mrs. Chevrolet, I'm sorry.
Chevalier.
Chevalier, thank you. It's French, obviously. I just want to clarify. Today's hearing is for the mitigation. What you're raising stems back to when the original notice of violation. You own property here in Pembroke Park, but you don't reside here. Okay.
Yeah.
Is that subject property rented out?
No, we only, that's our house that we bought, but we're renting the lot.
Okay. So what you're raising at this stage in this process is something that should have been raised at the hearing on the subject violation. And so while I understand your position with regards to had you known, right? I'm surmising, had you known sooner or things of that nature. And so I do understand that. And for property owners, whether or not you reside in the property, it is ultimately your responsibility. And so just so that we are adjudicating the proper form of what we're here today, it's your mitigation request. And it's been approved. In fact, it's been approved by 90%. And so to that extent, related to the mitigation, other than your position that you didn't receive the initial notice that went back to sender, what is your position as to the amount that the town has approved for reduction?
Well, we did resolve and corrected everything in 83 days. If you take a look at the, I don't know what's the sheet, it's all the date that you can see that what happened since we found out that letter on this, on the floor. We complied with everything in 85 days. So if we would have known at the beginning, we would never be, you would never had an hearing. Everything would have been fixed, resolved, or everything. That's why we're contesting that fine. And that fine at 9,000, we only knew yesterday. They sent us this at 4:30. So we didn't know until this morning. So that's why we're contesting everything.
Well, this is not the hearing to contest. I want you to be clear on that.
Okay. Yeah.
This is the hearing. The town has stated what they're reducing it to, and your position is that you don't agree with that reduction?
Exactly.
Okay. You have a counter position as far as what you're asking the special master to reduce it to?
Say that again, I'm sorry, I didn't.
This town has offered to reduce it to $1,080. It was almost $10,000 based on the days it was out of compliance. And you are rejecting the $1,080?
Exactly.
Okay.
Because I paid a permit, everything was fixed. I paid $300 for my permit, to fix everything that was on there. That's why I don't think there should be a fee. If we would receive everything, I don't think there should be a fee. At the beginning, the beginning of all that.
So what I'm hearing is that you're looking for a zero reduction?
I'm looking forward to just paying the $100 fee, and that's it. Because we complied to everything. We did resolve everything with the city. We spent 85 days working hard, to advance in that file. Nobody told us that we could, when we came and asked Mr. Guston, come on, first of all, he just showed us the fee was $10,400 at the beginning, and yesterday I found out it's $9,900.
Ms. McKinney, if I may?
Yes.
May I ask a few questions? I'm looking at the file, Ms. Ramirez. The notices were actually posted on the property, correct?
Correct.
So as far as under Chapter 162, if they were mailed, obviously there was mail there, that is done correctly. The testimony before you is that the respondent removed their mailbox. Of course, the town is not in control of that. And then throughout the process, the testimony of Ramirez that it was posted on the property. Unless the city has any information or the respondent has a forwarding address or the city learns of any address, which did not happen in this case, is that correct?
Correct.
Then in that point, the town followed Chapter 162 for the proper notice requirements.
Did you understand that?
Yes, a little bit, but I just don't understand why we got here. And Mr. Guston didn't show us this, that invoice before that than yesterday. It's like,
But what
why did he make us fill the mitigation then?
so that you would have a almost $10,000 fine reduced if you so requested.
He told us to fill that out to say, I don't want to pay the fee. That's what he did to us. He said, fill that out and go.
Yes, but applying for mitigation doesn't mean you're going to get a zero reduction. It doesn't even mean you will be given a reduction, right? So just to put things in context for the purpose of having a record, and you may recall from the case prior to yours, the city sends out the notices certified mail. That is all they're required to do. You actually receiving it is not a requirement. The notice is also posted. And part of that reasoning, and this is U.S. Supreme Court constitutional law on this subject, part of that reasoning, and I stated this to you, is that you are the property owner. You are an owner of property that you don't reside in. All the more reason that you should be more on top of because you're physically not there. Thirdly, this hearing is to go over the mitigation. And I just want to be clear on the record because the alternative by rejecting the town's proposal for mitigating of $1,080 could result in the fines being exactly what they were, $9,900. So again, I'm going to pose the question, and that is the town has agreed to reduce the fine amount from $9,900 to $1,080, which is a 90% reduction. And I understand everything that you've stated, but with regards to notice, as per the testimony of the officer and what the town attorney has placed on the record by the responses you've provided, notice was satisfied.
Listen, $500. And I even went see, when I saw Justin Guston, I said to him, if the fine, he didn't say an amount. I said, if the fine is $500, fine, I'll pay. Mm-hmm. Next thing I know, he gives me this, fill that out, bring it back with the check, $100. That's what I did. Then I saw the fine that was $10,400 by another person. But I said, if it's $500, I would have paid right now. But now we're here, and we received the $9,000, the $1,000 only yesterday at 4:30.
So
I understand.
So
the other thing that I do want to take a note is because I am looking at the actual case, the underlying violations were are pretty, not following the code. There's a lot of installations and work having been done without procuring a permit. So considering the underlying violations, I understand, considering the underlying violations, and I do applaud you for coming into compliance because that is what the town is seeking. With regards to the reduction by the town and your request of $500, I am going to deny your request for a further reduction.
But the only thing on all the letters that I received is only one window. The rest was all okay. It's one window. And I even paid the permit for $300 for one window that we didn't change because we bought it in 2010 and we had to comply with the city, which we paid. But it was one window at the end.
the inspection accepted like this.
And the inspection was accepted like that. So everything that's in here, everything was sold except one window, which we paid a permit for. That's why I'm telling, $1,000 for one window plus the permit? If it's like that, I'll pay, but
No, just to be clear, these fines are a result of the number of days that the property was not in compliance. This is an
Okay.
accrual. So I just want to be clear so we understand the process and the purpose of today's hearing, which is a request for abatement of fines. Do you have anything else before I give my formal pronouncement?
I said everything I had to say.
Thank you so much. Based on the testimony and the evidence presented, I do want to emphasize that although the respondent raises notice, their notice has been satisfied in accordance with 162. In furtherance, there is substantial and competent evidence to approve the town's abatement recommendation of a reduction from $9,900 to $1,080, which is what the fines are mitigated to. You are assessed $100. That 1080 includes the $100, Officer Ramirez?
Yes.
Okay, thank you. You must pay this reduced amount within 30 days, or the original amount of $9,900 will resume.
Where do I pay?
You can pay tomorrow because we have to process this form, the abatement form, okay?
Thank you.
We come in the front tomorrow?
Yes, you can come in the building department.
Thank you.
You're welcome.
Is that it?
Ma'am, sir, can you please hold a second? I will give you a copy of your order. Thank you.
You're welcome. We can call the next case.
Next case is 6999. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, property owner Excelente LLC, site address 4250 West Hallandale Beach Boulevard, Pembroke Park, Florida, Unit 6. A notice of hearing to abate fine was requested via email on December 20, 2024. It is the town's motion to reduce the fine of $119,657 by 85%. And the total amount is $18,082. That includes the admin fee, the recording lien fee, and the release of lien fee.
Is there anyone here on case number 6999? Please come forward. Good morning. Can you please state your name and your relation to the subject property?
Johnny Fronto Jr., I'm the tenant.
Okay. Are you here on behalf of the owner of the property?
Yes.
Okay. So this is a abatement of fine request. You've heard the officer. What's your position with regards?
I would like to ask, can it be reduced by 90%? And would I be able to get more time to actually pay it rather than 30 days?
Okay, so Officer Ramirez, this is a reduction by 85. This is $18,082.
This is the standard 85% for properties in this nature. That they're businesses that have to be compliant. So 85% is the standard.
So the town's position is that they are not in agreement with the 90% reduction.
Okay.
You are in a commercial establishment. You are a business for profit. And so all properties in the town need to be in compliance. So.
Okay, so with that being said, would I be able to get more than 30 days to pay this fine?
Yes, you can. How much time are you requesting?
the maximum allowed. I mean, it's $18,000. We're just about to open, so there's no cash flow right now. So
The maximum is 120 days.
that would be perfect.
Okay.
Ms. McKitt, as stated before, but I also want to state on this case that if that money is not paid within the time frame for the respondent, then it goes back to the full amount.
Right.
Officer Ramirez, can you please restate that full amount that,
$18,082. That includes the admin fee, the recording lien fee, and the release of lien fee.
no, the original fine amount, please?
The original is $119,657.
Did you hear that?
Yes.
Okay.
And can payments be made on this, or have to be paid in like one lump sum?
You can make payments on it. Just make the full payment by the 120 day.
Right.
Okay.
Gotcha.
Anything else?
No, that's it.
Okay, I'm going to give my oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for abatement. Your fines are mitigated to $18,082. That includes the cost of the assessed hearing fee, as well as the recordation. Failure to pay that mitigated amount in 120 days will result in the original fine amount of $119,657 to resume. So please be sure to make payments in that time period, and within 120 days, the full $18,082 must be paid. Okay? Good luck to you. We can call the next case.
Next case is 8243. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, property owner 5525 Southwest 41st Street, Pembroke, LLC, site address 5525 Southwest 41st Street, Pembroke Park, Florida. A notice of violation was sent by regular mail February 17, 2023. A notice of hearing with a copy of the notice of violation was sent by certified mail January 31, 2024, posted to the property in Town Hall February 9. The violations are for replace old toilets with new toilets for each unit without permits. There's a total of 82 units. Obtain an after-the-fact permit and inspections for 82 units. This has not been corrected. Item number 2, 3 unknown commercial dumpsters on the premise. Property owner must obtain dumpsters from Waste Management as they are the exclusive franchise within the town limits. This has been corrected. Item number 3. And I'm sorry, this has been corrected as of January 31, 2024. Item number 3, portable container on premise. Portable containers are prohibited. Remove portable container from premise. This also has been corrected as of January 31, 2024. So the only remaining item is obtaining permits for the 82 units, the toilets that were installed without permits. As of today, there is no permits for those toilets that were replaced. So it is the town's motion to give them 90 days. That way we can see them putting effort as to getting these permit applications, getting them in inspections from the chief plumbing. And if not, a per diem of $250 and a $100 admin fee.
Is there anyone here on 699?
Hi.
Please state your name and your position with the
My name is
property.
Stephanie Dunn. I'm the property manager.
Okay. Okay, so Ms. Dunn, you've heard Officer Ramirez and the testimony. What's your position with regards to the violation?
I'm totally new at this property, so I do agree with the fact that she's offering us 90 days to comply. I have been making efforts to comply with the other ones. So I appreciate the fact that she's giving us the 90 days.
Okay, so if there's nothing further, I'll go ahead and give my oral pronouncement. Based on the evidence and testimony presented, I do find there is substantial and competent evidence to support the town's position, the existence of the violation. The respondent is ordered to come into compliance within 90 days or face a $250 per day daily fine. There is $100 assessed for today's hearing. I do want to encourage you to apprise the respondent that please commence procuring the permits. It's 82 toilets, which will require inspection of each. So get the permit application in so it can be approved so that the fines don't accrue. Good luck to you.
Thank you.
Ms. Dunn, there's still one more case for the property if you want to stay there.
Yep.
That's case 8439. Just let me know when you're ready. Yep, you're okay. Chief Code Compliance Officer for the Town of Pembroke Park, Joseline Ramirez. Property owner, 5525 Southwest 41st Street, Pembroke Park, Florida. Site address, 5525 Southwest 41st Street, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail January 31, 2024. Posted to the property February 9, 2024. It is the town's motion to confirm the fine of $32,100. This accrued over 128 days. Per diem fine is $250.
Sorry, Joseline. What is the case number?
8439. Section 8.4. You're welcome. Okay. Again, your name for the record and your relation to the subject property.
It's Stephanie Dunn. I'm the property manager.
Okay, so Ms. Dunn, this particular case is here so we can confirm the fine. The town's position is to confirm the amount of $32,100. There is a daily accrual of $250. What is your position with regards to that?
Does the 250s continue to occur?
It does continue to accrue until the subject property comes into compliance, and then the total sum of what's accrued would be the amount that's due and owing to the.
For time to procure the permits and fill out the mitigation form, if possible.
So the mitigation process can begin when those permits for the plumbing work that was done behind the building. Once those permits are completed, then we can start the mitigation process. But right now, this case is in compliance. It's not in compliance.
Yes, I understand. So until those permits have been completed, I'm still going to incur a fine? Okay. All right, I understand.
Anything else, Ms. Dunn?
No, ma'am.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. The fines are hereby confirmed at an amount of $32,100. The fines are continuing to accrue at a daily fine rate of $250. $100 is of administrative costs are assessed for today's hearing. The respondent is ordered to comply, or again, the fines will continue to accrue. If you have any questions, please stay in contact with Officer Ramirez.
Yes, ma'am.
Good luck to you. You'll receive an order. This is for confirming. We're confirming.
Has everybody signed in? Okay.
She has two cases.
I need that.
The first one.
The two more cases?
The first one I wrote 100. Okay, 32,000. Yeah.
No.
Oh yeah, you're right. 250. It's
Okay.
250.
And put your initials and here. Or you want me to print
Yeah,
it again?
white out.
No. You want me to print it again?
Yeah.
Es que se equivocó el 82.
We can call the next case.
Next case is 7152. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, property owner Park 31st Corp., site address 1985 South Park Road, Unit Number 1, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail January 31, 2024, posted to the property and town hall February 9, 2024. It is the town's motion to reduce the fine of $42,900 by 85%. This includes a 100 admin fee. The total amount is $6,520, and the business owner is in agreement with this amount. So we did draft an agreed order.
Okay, excellent. Is anyone here on case number 7152? Good morning. If you could please state your name for the record and your relation to the subject property.
Good morning. My name is Adelmo de Jesus. I'm the tenant over there, and I am the general manager of the facility.
Okay. So the testimony of the officer is that the owner is in agreement with the property. There's a draft agreement. So unless you have anything to add, I'll just go ahead and provide my oral pronouncement.
I'm okay. I just want to say thank you to everybody. It was a long trip, but I enjoyed it. Thank you.
And thank you.
Based on the testimony and the evidence presented, there is substantial and competent evidence to approve the request for abatement. The record reflects that the town and the subject owner of the property are in agreement with same. The fines are mitigated down to $6,520. This does include the $100 administrative cost for today's hearing. The mitigated amount must be paid within 30 days or the original fine amount will resume. Good luck to you.
Thank you.
You're welcome.
Thank you.
Next case.
Next case is 8547. Chief Code Compliance Officer for the Town of Pembroke Park, case 8547, property owner Ventura, Unit 120, Inc., site address 5100 Southwest 41st Street, Unit 318, Pembroke Park, Florida. A notice violation was sent by regular mail May 23, 2023. A notice of formal hearing with a copy of the notice violation was sent by certified mail January 30, 2024, posted to the property and town hall February 9, 2024. The violations are 2 bathroom renovations done without permits, obtained plans for an after-the-fact permit, and complete all inspections. This has not been corrected as of January 29, 2024. Item number 2, install AC unit without a permit. Item number 3, install water heater without a permit. Item number 4, kitchen renovations done without permits. Item number 5, mold-like substance in bathroom area and door entrance area. Remove mold-like substance and infestation. Provide remediation report. All these items have not been corrected as of January 29, 2024. And it is the town's motion to give the property owner 60 days, if not a per diem of $250 and a $100 admin fee to correct all these violations.
Is there anyone here on case number 8547?
Good morning, Joel.
Good morning. Can you please state your name and your relationship to the property?
My name is Albert Montoto, and representing the owners.
Okay. We're here on the violation. Can you please state the position with regards to the violation on the existing property?
Yeah, I mean, from the very beginning, we have a long time difficulty to obtain the permit process and the letter from the association. It took a long time for the association to give us an authorization to commence with the permit. Then we applied for the permit, building permit, problem finding plumbing, problem finding a electrical and mechanical. Finally, last night, I was able to submit the last of the permit, which it was the electrical permit. And we need to see if we can get the maximum time allowed for the extension, so we can finalize all this permanent, in the time that need to be done.
So the town's position right now is to provide 60 days for you to be able to come into compliance.
I hear that, to see if we can extend that to at least 120.
What's the town position on the respondent's request for 120 days?
Town's position is to
Please.
add 90 days, and they can request an extension after those 90 days, given the fact that you have made efforts putting forth the permit applications and getting approvals, okay?
Appreciate it.
All right.
Yeah, appreciate it.
Okay, anything else?
That should do it.
Okay.
Thank you.
I'll give my oral pronouncement. Based on the evidence and testimony presented, I find that there is substantial and competent evidence to support the town's position, the existence of a violation. The respondent is hereby ordered to come into compliance in 90 days or face a $250 daily accrual of fines. The respondent is also assessed $100 administrative cost for today's hearing. Good luck to you. Eight five four seven. 8547. You can print that part out. Yes. Okay. Okay. Let me just verify the address. It's good. Okay. 90 days. 250. Okay. Next case, please.
Next case is 8797. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park. Property owner LUMAX Investments LLC. Site address 5501 Southwest 33rd Street, Unit 1 and 2, Pembroke Park, Florida. A notice violation was sent by regular mail August 11, 2023. A notice of formal hearing with a copy of the notice of violation was sent by certified mail January 30, 2024, posted to the property and town hall February 9, 2024. The violations are install new windows without a permit. As of January 29, there is a permit in progress with failed inspections. So we are waiting for the completion. Item number 2, install new doors without a permit. There's also a permit that is tied with the window permit, and that has to be completed as well. Item number 3, gravel piled on swale. The gravel has been removed. and the swell areas are kept up as of January 29, 2024. It is the town's motion to give the property owner 30 days to complete these permits, if not a per diem fine of $250 and $100 MMV.
Anyone here on case number 8797? Good morning. If you could please state your name for the record and your relationship to the subject property.
My name is Luciano, and I'm the owner.
Okay. So, Mr. Luciano, we are here on the notice of violation that was issued. You've heard the testimony from the officer, and their position, the town's position, is to give you 30 days to come into compliance or face a daily $250 daily fine.
Okay. We asked for inspection for the window one, but the inspector, he never showed up. So, for the windows.
You called in the town for an inspector?
Inspection, yeah.
Okay.
That's why.
Have you followed up?
No, we need to reschedule.
Okay. So that's something that you definitely want to do.
Yeah.
This violation, let me just scroll up. Yeah, this violation was originally issued back in August of last year. We're in 2024. So that's a while ago. So I would strongly urge that you follow up with the building division to coordinate a date and time for those inspections to be done.
Okay, we called inspection last week. We applied for the permits. We called it last week. So the inspector never showed up. That's why it failed, the inspection. But we did call inspection.
Okay, and what I'm saying is to come into compliance, you're going to have to continue with your proactiveness in getting an inspector out. Right now, you have no fines accruing, and this violation was issued back in August of last year. So today we're at the final hearing because you're not in compliance, and so the town is seeking to give you 30 days, and then the fines will start.
Okay.
Okay, do you
Is there any
understand
way
that?
we can extend those 30 days to 60 days to apply for the other?
I don't have no objection.
Okay, so the town is in agreement, as opposed to giving you 30 days to come into compliance, excuse me, they're in agreement with 60 days, and the daily fine after 60 days will start to begin to accrue at $250 a day.
Okay.
Do you understand that?
Yes.
Okay. Anything else?
No, I have two cases.
Yes.
Yes, right now we're on 8797.
Okay.
So we're probably going to call your next case, so don't leave.
Okay.
Okay, I'll go ahead and give my oral pronouncement based on the evidence and testimony presented. There is substantial and competent evidence to support the town's position, the existence of a violation. The respondent is hereby ordered to come into compliance within 60 days or face a $250 daily fine. The respondent is assessed $100 administrative cost for today's hearing.
Okay.
Okay, we can call the next case.
Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, property owner LUMAX Investment LLC, case number 9004. Site address 5501 Southwest 33rd Street, Pembroke Park, Florida, Unit 1 and 2. A notice violation was sent by regular mail October 2023. A notice of formal hearing with a copy was sent by certified mail January 30, 2024. Posted to the property and town hall February 9, 2024. The violations are item number 1, per building official, interior renovations of the bathrooms for both units were done without a permit. Item number 2, per building official, new AC units were installed without a permit. Item number 1 and item number 2 are not in compliance as of January 29, 2024, because there is no after-the-fact permits for these work done without permits. Therefore, it is the town's motion to give 60 days, if not a per diem of $250 and $100 admin fee.
Okay. Can you please state your name and your relationship to the subject property for case number 9004?
My name is Luciano Rescaldani, and I'm the owner for the property. We purchased the property back in February, and they had the bathrooms and AC, I guess, done by the previous owner. And we are in the process of getting the permit for those violations. So we would like to accept the 60 days.
Okay.
Yep.
Based on the evidence and testimony presented, I find there is substantial and competent evidence to support the town's position that the existence of a violation is on the subject property. The respondent is hereby ordered to come into compliance within 60 days or face a $250 daily accrual of fines. The respondent is also assessed $100 administrative cost for today's hearing. Good luck to you.
Okay, thank you.
And please keep contact with me, and if you need an extension, let me know, okay?
Okay, we will.
All right.
Thank you.
Luciano, what is the gentleman's name? Leonardo. And same last name? And that's Leonardo. Okay.
We can call the next case.
Next case is 6655. Chief Code Compliance Officer for the Town of Pembroke Park, Joseline Ramirez. Property owner, Jonathan Rogers Silverio. Site address 3140 West Hallandale Beach Boulevard, Unit 909, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail January 16, 2024, posted to the property and town hall February 9, 2024. It is the town's motion to give the property owner 60 days to correct all violations. Per diem stays the same, and a $100 admin fee imposed.
Is there anyone here on case number 6655?
Good morning.
Good morning. Can you please state your name for the record and your relationship to the subject property?
Pelayo Roger Silverio, and I'm the owner.
Okay. So we are here on your request for extension of more time.
Correct.
The town has agreed to extend the time for compliance by 60 days.
Okay.
The daily fine amount remains the same.
Okay.
Okay.
So which should be my completion date
60 days from today's order.
from today? Okay. Permits were filed today. I do have some questions. Actually, I did pay them today. The contractor forwarded the link for me to do the payments today. It's been a struggle finding someone to do work in the city. I don't know why. Of 9 pages of contractors by the Broward County, nobody wants to work here. It's cost them to remove this AC. It's costing me over $2,500, which is an absurd amount. Okay. So I don't know.
Well, you do have an extension by 60 days.
Okay.
You are strongly encouraged to stay in contact with Officer Ramirez.
Okay.
If by chance additional time is required. Also, once the property does come into compliance, the town does offer a pathway for the abatement of fines. So you are strongly encouraged to make all efforts and diligence to bring the property into compliance and to stay in contact with the officer.
No, it'll be done within the next 10 days, roughly, because permits were approved and I paid already today. So
Okay. Okay, if there's nothing else, I'll go ahead and provide my oral pronouncement.
Okay.
Okay, thank you. Officer Ramirez, can you confirm what the per diem fine amount is for this?
$100.
Okay, thank you. Based on the testimony and evidence presented, there is substantial and competent evidence to support the request for extension of time. The respondent is hereby ordered to come into compliance within 60 days. After 60 days, the failure to come into compliance, the fines will begin to accrue at $100 a day until the property is in compliance. You are assessed $100 administrative cost for today's hearing.
Okay.
Good luck to you.
Yes, Nasli will give you a copy of the order.
Next case.
Next case is 6669. Chief Co-Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 6669. Property owner Nerida Flores. Site address 3140 West Hallandale Beach Boulevard, Unit 232, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail January 16, 2024, posted to the property and town hall February 9, 2024. It is the town's motion to give the property owner 60 days to correct the violation. The per diem stays the same and $100 admin fee imposed.
Is there anyone here on case number 6669?
Hello, good morning. My name is Nerida Flores.
Good morning. And Ms. Flores, who are you, Flora?
I'm the owner.
Oh, okay. So the town's position is to offer 60 days extension. The daily fine amount remains at $100. And of course, $100 administrative cost is assessed for the hearing. What's your position with regards to that?
Okay. They sent me on the, well, I received it, they sent it on the 11th, but I didn't receive it because my email, they had something going on with my email. So I received on January 16, I submitted the permit, and then they told me that I had to please provide plan indicating areas of drywall to be repaired to be more specific. So today I brought the new plan. So I don't know how long does it take to revision.
So since you've addressed the comments that the building department has given, what I would recommend is that following today's hearing is to stop by the building department to find out an approximate time frame with regards to the review of the new plan submitted and if any comments will be provided or whether a permit will be issued. If comments are issued yet again, you are strongly encouraged to stay in contact with Officer Ramirez.
Okay.
Okay?
All right.
So if there's nothing else, I'll go ahead and issue my oral pronouncement. Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for extension of time. The respondent is hereby ordered to come into compliance within 60 days. Failure to correct the violation and come to compliance will result in a daily accrual at $100 per day. You are assessed $100 administrative cost for today's hearing. Good luck to you.
Okay.
Okay. Next case is 7005. Chief Code Compliance Officer for the Town of Pembroke Park, Jocelyn Ramirez, property owner, Lydia Chavez Pineda, site address 3140 West Hallandale Beach Boulevard, Pembroke Park, Florida, Unit 802. A notice of hearing to extend time was sent by certified mail January 16, 2024, posted to the property and town hall February 9, 2024. It is the town's motion to give an extension of 60 days. Per diem fine stays the same, and the $100 admin fee imposed.
Anyone here on case number 7005? Good morning. Can you please state your name and your relationship to the property?
Lydia Chavez Pineda.
And Ms. Chavez, who are you with regards to the property? Are you the owner?
No le entiendo qué me dice.
Try your best. She says she doesn't understand what you're saying.
Is there anyone in the audience who's been sworn in who can translate for who speaks English and Spanish?
Thank you.
Sí, she is the owner of the property.
Okay. Can you tell us your name for the record?
Mariah Cruz.
Thank you, Ms. Cruz. So we are here on an extension request. The town's position is to give her, to extend the time for her to correct the violation by 60 days. The daily fine amount will then begin to accrue, and she will be assessed $100 admin fee. What's her position with regards to that?
Que te van a dar 60 días más para terminar lo que tiene que hacer con los violations. Después de los 60 días te van a cobrar $100 cada día.
Okay.
Madam Magistrate.
Yes.
And if the translator can state her name for the record.
Mariah Cruz. I did.
Okay.
She did.
Okay. I didn't hear on the mic, sorry.
Sorry.
Okay, great. So I'll go ahead and provide my oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for extension of time. The respondent is hereby ordered to come into compliance within 60 days. Failure to correct the violation into compliance will result in the fines of a daily accrual amount of $100 per day. The respondent is assessed $100 administrative cost for today's hearing.
Que te van a cobrar $100 por este hearing por hoy. Tiene los 60 días para terminar lo que tiene que hacer. Después de los 60 días son $100 cada día.
Okay, so please stay in contact with the officer.
Que queda en contacto con Jocelyn.
Okay.
Okay. Y Nancy te va a dar un papel con todo.
Okay. Gracias. Thank you.
You're welcome. Good luck to you.
Yes, you can stay there.
Next case.
Because it was added at the end.
Oh, yes.
But the 745 is in the agenda. The other one is not.
Yeah. The addition.
Okay. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, property owner Infinity Azure LLC, case number 7745.
Okay.
Site address 3302 Southwest 54th Avenue, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail January 16, 2024, posted to the property in Town Hall February 9, 2024. It is the town's motion to reduce the fine of $69,350 by 85%. That's a total of $387.50. That includes the admin fee, the recording lien fee, and the release of lien fee.
I'm sorry, Jocelyn, you said $10,387.50?
The total is $10,050 $10,544.50. We can round it up to $10,544.
10,000, okay.
We accept.
Yeah, okay.
Mariah Cruz, property manager. And we accept. Thank you.
Okay, thank you. I'll give my oral pronouncement. Based on the testimony and evidence presented and the agreement of respondent, there is substantial and competent evidence to approve the request for abatement. The fines are hereby mitigated to $10,544 even. The respondent must pay that amount within 30 days. That amount does include the $100 administrative cost, recording fee. Failure to pay that amount, $10,544, will result in the original fine amount being reinstated. Good luck to you.
Yes.
Next case.
Next case is 7958. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Property owner Infinity Azure LLC, case number 7958. Site address 3351 Southwest 55th Avenue, Pembroke Park, Florida. A notice of hearing to abate fine was requested on February 20, 2024. It is the town's motion to reduce the fine of $196,657 by 85%. That total amount is $29,632. That includes the admin fee, the recording lien fee, and the release of lien fee.
Okay, can you please state your name and your relationship to the subject property for case number 7958?
Mariah Cruz, property manager. And we accept. Thank you.
Based on the testimony and evidence presented and agreement of respondent, there is substantial and competent evidence to support the request for abatement. The fines are mitigated down to $29,632. This does include the administrative costs, the recordation lien and release of lien costs. The respondent must pay that amount within 30 days or the original fine amount will resume. Good luck to you. Thank you. Next case.
Next case is 6810. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Property owner, I'm sorry, I said the case. Property owner McNeil Wilson and Angela Wilson. Site address 5511 Southwest 32nd Court, Pembroke Park, Florida, Unit 1 and 2. A notice of hearing to abate fine was sent by certified mail January 31, 2024, posted to the property and town hall February 9, 2024. It is the town's motion to reduce the fine of $135,500 to 98.9%. That's a total amount of $1,647.50. The reason for this case is reassigned to me. Prior officer Eric Ridgewagon cited this property for maintenance and added $250 per diem per ordinance. So that's why the fine accrued to so much within 149 days. So this is the reason why that fine is reduced to 98.9%.
Is there anyone here on case number 6810?
Hi, Candace Wilson. I'm the property manager.
Hello, Ms. Wilson. And you are the gentleman next to you?
He's the owner.
Oh, okay. And his name for the record?
McNeil Wilson.
Okay. Ms. Candace, will you be speaking for Mr. Wilson? Or?
Oh, he can speak.
Okay. We're here on the request for abatement of fines. The town has reduced the fines down from $135,500 to $1,647.50. That includes the admin, recordation lien, and release of lien. Is that correct, Ms. Officer Ramirez?
Yes.
Okay. What's your position with regards to that?
Yes, I'm okay with that.
Very good. Based on the testimony and evidence presented in agreement of respondent, there is substantial and competent evidence to approve the request for abatement. The fines are mitigated down to $1,647.50, which includes the administrative cost of $100, record lien fee and release of lien fee. The respondent must pay this amount in 30 days or the original fine amount of $135,500 will resume. Good luck to you.
Thank you.
You're welcome.
Thank you so much, Nikki.
You're welcome. Thank you. We can call the next case. Oh, I'm sorry.
Tomorrow, because we have to process the order in the system. No problem. Are you paying by credit card or check? Okay, he can drop it off to the building department and we can process it for him. But we can send him if he leaves his email, we can send him a receipt or by mail.
We can call the next case. You're welcome. Good luck.
Next case is 5167. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, property owner Michael Chambers, and Jana Plummer. Site address 3433 Southwest 52nd Avenue, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail January 31, 2024, posted to the property in Town Hall February 9, 2024. It is the town's motion to confirm the fine of $42,300. This per diem fine of $50 accrued for 844 days.
Is there anyone here on case number 5167? Good morning. Can you please state your name and your relationship to the subject property, please?
Michael Chambers.
Mr. Chambers, are you the owner of the property?
Yeah.
Okay, so we're here to confirm the fine. The fine that has accrued at a $50 a day daily rate, the amount accrued so far is $42,300. And that's approximately for over 800 days. So that's over 2 years of non-compliance.
You see, I'm a truck driver. I was out of town driving trucks. I didn't know nothing about this. I just started working local for the past 6 months. So I didn't know nothing about this until I come home and see this on the fence.
Okay. You're the property owner?
Yeah.
Yeah. Okay.
The-
Madam Magistrate, how do you want to proceed with this? Because as you mentioned in the past cases, this is not a contestment.
Right. So, Mr. Chambers, you've sat through the whole hearing. And while I understand what you're saying, that you were working and you're a truck driver, so that takes you away from your property. And I understand because that's how you make a living. But at the same time, you do own property in the town. You are ultimately responsible for the subject property, making sure that it is up to code, it is compliant, and such. The property has received notification. The officers provide notice as per the testimony pursuant to the Florida statute. And so today, we're here to confirm that amount. And in this case, your fine amount, I must say, was only at an accrual of $50. But the amount that we're confirming, that the town is seeking to confirm today, demonstrates nothing has been done. And so while you are now here working locally, and that's a good thing because you can stay on top of, you are strongly urged to bring the subject violations into compliance. But as for today, the fine amount that the town is seeking to confirm is the $42,300. And I do want to add that $50 daily accrual is still accruing, and it will continue to accrue until the entire subject violations on the property for this case number are complied with. You have anything else to add?
I don't have $42,000 to pay for.
Well, for today, the subject hearing today is the town is seeking to confirm that amount. You have to bring the property into compliance,
Yeah,
and then you will be able to submit a mitigation application request. And if that amount is approved and subsequently reduced, it would be a lesser amount. Okay.
The first step is to obtain your permits for the fence that was installed. And once you close that permit, we can move forward with the mitigation process.
Okay. How do I get a list of contractors that do fence permit? Because since I get this letter, I can't even get in touch with the homeowners association.
If you go to the building department, you can speak with Jeffrey right now, and he'll assist you. And let me.
And Mr. Chambers, if you don't have anything else to add, I'll go ahead and provide the oral pronouncement, okay? Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. The property does remain not in compliance. The fines are hereby confirmed. The amount confirmed is $42,300. The fines are still accruing daily at a daily rate of $50. You are assessed $100 administrative cost for today's hearing. Good luck to you, and please stay in contact with the officer and the building department to get going with pulling the permit so that the property can come into compliance. Hopefully you didn't get wet in the rain. Sunday.
Yes. Jocelyn? Yes. Here, front. We are taking a break or we are continuing?
Do you guys need a break?
Yeah.
I took my break before we got started.
I took my break midway. I couldn't wait.
We're back on the record.
All right, there's no one in the audience, so we will go in the order of the agenda. The next case is 8721. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, property owner 3520 W LLC, site address 3520 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice violation was sent by regular mail, July 11, 2023. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, January 30, 2024, posted to the property and town hall, February 9, 2024. The violations are item number 1, operating without a business tax receipt or certificate of use. Item number 2, swale area is full grown, weeds and dead vegetation. Remove dead vegetation and trim overgrown vegetation. As of November 6, 2023, the swale area was trimmed, but the trash and dead vegetation was not cleaned up. So it's not in compliance. And item number 3, commercial dumpster located on property does not adhere to the town's franchise agreement. Remove MST scrap metal dumpster and change to waste management service dumpster. This dumpster has been removed and is in compliance as of January 29, 2024. So the only items that require correction is obtaining a BTR, the business tax receipt, and cleaning up the swale area. It is the town's motion to give 30 days to comply. If not, a per diem of $250 and a $100 admin fee.
Anyone here on case number 8721, seeing no one come forward, based on the evidence and testimony presented, there is substantial and competent evidence to support the town's position of the existence of a violation. The respondent is ordered to come into compliance within 30 days or face a $250 daily fine. $100 administrative costs are assessed for today's hearing. Next case.
Next case on the agenda is case 9076. Property owner 5525 Southwest 41st Street, Pembroke, LLC. This case has been dismissed because it became in compliance as of yesterday, February 20, 2024. Next case is 9233.
Officer Ramirez, with regards to case number 9076, does the town issue findings of fact?
No.
Notwithstanding compliance? Okay, so the record reflects that case number 9076 is dismissed for coming into compliance. Anyone here on case number 9232, seeing no one come forward? And you can begin your presentation for 9232.
Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 9233, property owner Cole FD Portfolio 3 LLC, care of Family Dollar Store 26608. Site address 4100 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice violation was sent, a notice of formal hearing and with a copy of the notice violation was sent. Certified mail, January 30, 2024, posted to the property and town hall February 9, 2024. This is a repeat violation referencing case 8977. The final order has been submitted into the record. And the violations are swale area is full of bulk trash and debris from illegal dumping. Remove bulk trash and debris from illegal dumping. Item number 2, abandoned property, blue truck on back end of the property. Item number 3, no parking on swale area. Remove all vehicles and maintain swales according to town ordinance regulations. And then also, I cited under section 1246, which states that failure of the owner to comply with notice, assessment for correction by the town upon the failure of the property owner or owners to remove the condition creating the nuisances as foresaid within the designated time period, the town shall cause such condition to be removed and shall assess the owner or owners of the property for such service in the amount equal to costs incurred by the town in the removal and disposal of the garbage, trash, rubbish, or other debris, which costs shall include but not limited to disposal fees, removal expenses, including both labor and vehicular expenses, and an administrative fee in the amount of $250. And that if the owner or owners shall fail to correct the condition within 15 days, the town may enter upon the premise and remove the condition creating the nuisance. And the cost of the same will be assessed against the property. And if not paid within 30 days after the receipt of the statement for the same by the owner or owners, a lien will be filed against the property and an estimate of the cost removing nuisance if the town does so upon the failure of the property or owners to do so. So in this particular case, they had until February 10 to correct the violations. They did fail to correct this violation, so the town did go ahead and cleaned up. The town's franchise waste management did go ahead and remove all the bulk trash. And on February 16, upon reinspection, I spoke to Edgar, who was the hired landscape company to come out and pick trash. However, the bulk trash has already been removed. And so what Edgar did was remove the small trash like tires and small debris. So that was cleaned up by the landscaper. I do want to impose the fine from the date of the correction that was designated to be on February 10 to the compliance date, February 16, 2024.
Do you have that amount?
It would be a per diem of $500 from February 10 to February 16, since it's a repeat.
And that's for the violation of 12-46, or you're seeking? It's a repeat violation.
Yeah, for section 12-41, 12-46, 22, 29. The total, we don't have the total but the $500 is the per diem that we will be imposing.
Reflective of February 10th, 2024 to February 16th, 2024?
Yes.
Okay. And as to the actual costs that are owed to the town for remediating the violation under 12.46?
So Waste Management does the billing directly to the property owner.
Okay.
That said amount has not been submitted to me.
Okay.
But I will put it on the record once we impose a lien.
Okay, very good, thank you. Correction as to the case number. Anyone here on case number 9233? Seeing no one come forward. Based on the evidence and testimony presented, I do find there is substantial and competent evidence to support the town's position as to the existence of a violation. The following amount is hereby imposed reflective of a date of February 10th, 2024 to February 16th, 2024, a $500 per day daily fine for said time period. The respondent is hereby further noticed again by this order that they are required to pay the invoice for the town remediating the violation as per code section 12-46. The respondent is also assessed $100 in administrative costs for today's hearing. Next case.
Next case is 9255. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Property owner Hanlix Properties LLC. Site address 4790 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice form of hearing with a copy of the notice violation was sent by certified mail January 30, 2024, posted to the property and town hall February 9, 2024. The violations are for item number 1, trash and debris around all perimeters of property. Landscapers are using blowers and trash is spilling onto road. Remove trash and debris and maintain property clean periodically as needed. Item number 2, dead hedge on back end of the property requires replacement. I have been in contact with the subcontractor for Dollar General. And they have been picking up trash. However, there's every single time that I go there for inspection, there's always trash. So I have told them to make sure that it's entirely clean and to call me the same day, because it could be possible that if they wait certain days, then people dump more trash. They are close to a school zone, and so they did mention that a lot of kids come around and possibly just throw trash. So I explained to them that there's other adjacent properties that maintain their properties clean, so they have to do as well. I'm gonna recommend 15 days for full compliance, if not a per diem of $250 and $100 admin fee.
Anyone here on case number 9255? Seeing no one come forward. Based on the evidence and testimony presented, I do find that there is substantial and competent evidence to support the town's position with regards to the existence of violation on the subject property. The respondent is hereby ordered to come into compliance within 15 days or face a $250 daily fine. Administrative costs in the amount of $100 are assessed for today's hearing. Next case.
Next case is 5148. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Property owner Vincent A. Wicker Bell and Marie Nazej. Site address 3900 Southwest 52nd Avenue, Unit 701, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail January 31, 2024, posted to the property and town hall February 9, 2024. It is the town's motion to confirm the fine of $41,550. This accrued for 829 days.
That amount was $41,550?
Yes.
Thank you. Anyone here on case number 5148? Seeing no one come forward. Based on the evidence and the testimony presented, I find that there is substantial and competent evidence to support the town's position to confirm the fines. The fines are hereby confirmed at an amount of $41,550. The respondent is ordered to come into compliance and correct the violation. Failure to do so will result in the daily accrual of the per diem fine amount. Respondent is also assessed $100 administrative cost for today's hearing.
Next case is 5801. Chief Co-Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Property owner Louis Roca / Cobblestone 2 BMB LLC. Site address 2402 Susan Lane, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail January 16, 2024, posted to the property and town hall February 9, 2024. It is the town's motion to reduce the fine of $34,157 by 90%. The total amount is $3,557, and that includes the admin fee, the recording lien fee, and the release of lien fee.
Case number 5801, seeing no one come forward. Based on the evidence and the testimony presented, I do find that there is substantial and competent evidence to support to approve the request for abatement. The fines are mitigated down to $3,557. This includes the administrative cost of $100 for today's hearing, recordation lien fee, and release of lien fee. The respondent must pay this amount within 30 days. Failure to pay this amount in 30 days will resume in the original fine amount. Next case.
And for the record, I did speak to Brian Angus. He's the attorney for this case, and he is in agreement with the amount as well as the property manager. So we did draft an agreed order.
Thank you. The record is so noted. Okay, I'm sorry. Thank you. Next case.
Next case is 7587. Chief Code Compliance Officer for the Town of Pembroke Park, case 7587, property owner Jose Colmeneras / Claudio Colmeneras. Site address 2307 Southwest 31st Court, Pembroke Park, Florida. A notice of hearing to extend time was sent by certified mail January 31, 2024, posted to the property and town hall February 9, 2024. It is the town's motion to give the property owner 90 days, and the reason is because Jose Colmenera did pass, and from his passing, the brother Claudio Colmeneras overtook the property and has recently received a court order that he's able to now take care of the property and anything that's tied to it. So therefore, this is the reason we're giving the extension, as he was unable to do corrections before. The per diem fine stays the same, which is $100 per diem, and the $100 admin fee imposed. And the brother Claudio Colmeneras is in agreement with the 90 days.
Case number 7587, seeing no one come forward, based on the evidence and testimony presented, there is substantial and competent evidence to approve the request for extension of time. The respondent is ordered to come into compliance within 90 days. Failure to correct the violation and come into compliance will result in a per diem fine of $100 a day until the property is in compliance. Respondent is assessed $100 for administrative costs. The record does reflect that by testimony of the officer that the brother has now, by order of court, authorized to resume with complying and correcting the violations. Next case, if any, or any other business before for today's hearing?
That concludes all my cases. Thank you.
Okay, we are